my good friend and the Honorable Chief Justice of Kerala High Court, respected judges of Kerala High Court, former and sitting, the learned Advocate General, respected senior advocates, the trustees of this Sarada Krishna Sadgamaya Foundation for Law and Justice, law friends, students, distinguished invitees. It is indeed an honor and privilege to have been invited to deliver Justice Krishna Iyer 5th Memorial Lecture, who is considered as an icon of the robed brethren and the savior of the robbed classes. The greatness of Justice Krishna Iyer is that even in capturing his multifaceted personality, we will have to borrow his own words rather than our words. Therefore, I would do well to quote what he said of himself and his contribution, rather than clothing it with my own words. This is what Justice Krishna Iyer said of himself. I quote, "My life has had an arboreal feature, a variegated vicissitudes. Now a professor lawyer, sometime in jail, then a creative talent with multiple portfolios as successful minister, back to the High Court bar, off to the bench, flight to Delhi as member of Law Commission. Then came the brotherhood stage in the Supreme Court with innovative curial experiments, with truth and justice playing truant, and judicial efforts to democratize remedies, working restlessly for making law, people, and justice synthesize. And law of all, the scene of life is near sunset, yet yawning, and so long as the candle lasts, burning for public causes. This twilight, yet bright, span is dedicated for campaigns and claims every hour, every day. Some brethren, making busy money or ambitiously chasing post-retirement offices, may scorn at me for a tireless tongue and a fearless pen. True, it's all words, words, mere words, no matter from the heart. My waning life is but a struggle for lost causes, forsaken beliefs, unpopular names, and impossible loyalties. Fail I may, fight I must, since I am a human being, and everything that affects any human anywhere is never alien to me. I unquote. This is how Justice Iyer described himself, and I do not think that anybody can add or subtract anything out of what he said, even while describing him. Therefore, I thank the trustees of this foundation to have given me this honor and privilege. As Soli Sorabji said, Justice Krishna Iyer's most signal contribution to the development of constitutional law is his creative, expansive, and humanistic interpretation of Article 21. This singular aspect of his judicial career, according to Soli Sorabji, justly entitles him to a rank among the great and a permanent place in the hearts and minds of the needy and the neglected, the destitute and the despised, the poor and the suffering. In fact, people of India. Therefore, it is befitting that the topic that we have chosen for discussion today has something to do with a facet of Article 21 of the Constitution. I would divide my lecture into three parts. The first concerning For the first, providing a glimpse of the development of the law of privacy, right to privacy in India. The second part of my lecture providing the history of the evolution of this law in the Western world. And the third part of my lecture will be focused on how in today's world science and technology has impacted this right to privacy. Taking the first part relating to the development of law relating to right to privacy in India, I should say that Indian courts started off with a very negative note in the earliest of cases concerning the right to privacy. In the decision in 1984, rendered in 1954 in MP Sharma versus Satish Chandra, the Supreme Court held that there is no justification to import the right to privacy in our Constitution by a process of strained construction analogous to the American Fourth Amendment. This is how we started off in 1954. But in the year 1963, the right to privacy was recognized as part and parcel of the right to life guaranteed under Article 21 in a minority view expressed by Justice Subba Rao in Karak Singh versus Union of India, State of UP. In that case, in Karak Singh's case, a person was charged with a case of dacoity. He was later released for lack of evidence, but a history sheet was opened under the UP police regulations and he was put under surveillance. He was required to make frequent visits to the police station, and the police used to make domiciliary visits to his house very often. When he challenged these actions of the police on the ground that they violated his rights guaranteed under Article 21, the majority took a view that surveillance was not proper and they infringed Article 21. But they did not talk about this domiciliary rights. But Justice Subba Rao, in his minority view, highlighted the essence of Article 21 as encompassing within itself the right to privacy. Justice Subba Rao said in his minority judgment as follows, I quote, "The scientific methods used to condition a man's mind or in a real sense physical restraints, for they engender physical fear, channeling one's actions through anticipated and expected grooves. Further, the right to personal liberty takes in not only a right to be free from restraints placed on his movements, but also free from encroachments on his private life." This is how Subba Rao encapsulated the right to privacy in 1963. While UP police regulations were under challenge in Karak Singh's case, identical regulations passed with the government of Madhya Pradesh were under challenge in the next case to come up before the Supreme Court, and that was the case in Govind Singh versus State of MP. It was in 1975. The petitioner before the Supreme Court had identical complaints against the police as Karak Singh had against the UP police. Though the court in Govind's case found that the regulations impugned the writ petition would ill accord with the essence of personal freedom, the court upheld the regulations on the ground that there are serious problems in defining the essence and scope of the right to privacy, and that there are serious questions about the propriety of judicial reliance on the right that is not explicit in the Constitution. Supreme Court thought in Govind's case that court cannot go beyond the texture of what is provided in the Constitution and by a strained process of construction, taking it analogous to the American Fourth Amendment, they cannot read any right which is not explicit in the Constitution. That's what in Govind Singh the Supreme Court thought. In fact, The view in Govind was authored by Justice K.K. Matthew, who belonged to this part of India. However, Justice K.K. Matthew encapsulated the essence of this right in wonderful words. He said, the broad contours of the right to privacy is something that must encompass and protect the personal intimacies of home, family, marriage, motherhood, procreation, and child rearing. Expanding this theory further, K.K. Matthew said as follows, I quote, rights and freedoms of citizens are set forth in the Constitution in order to guarantee that the individual, his personality, and those things stamped with his personality shall be free from official interference, except where a reasonable basis for intrusion exists. Matthew went on to say, many of the fundamental rights of citizens can be described as contributing to the right to privacy. And he went on to say something very interesting, which is very, very personal to all of us, which all of us would agree, but we will not be bold enough to say it on a mic in front of the public. K.K. Matthew said, individuals need a place of sanctuary where they can be free from societal control. The importance of such sanctuary is that individuals can drop the mask, desist for a while from projecting on the world the image they want to be accepted of themselves, an image that may reflect the values of their peers rather than the realities of the nature. All of you know that every one of us is comprised of three personalities. What others think we are, what we think we are, and what we truly are. All these three are completely different. And in a sanctuary of his home, a man drops his mask and reveals unto himself what he truly is, rather than what he wants others to believe what he is. This is very beautifully brought out by K.K. Matthew in Govind. But even Govind did not take the law of right to privacy further. The next case that proved to be a milestone was R. Rajagopal versus State of Tamil Nadu. That was a case where a prisoner by name Otto Shankar, who was convicted of several murders, rape, etc., he wrote his autobiography while he was inside the jail, and he passed on the hard copy through his wife to the editor of a weekly magazine. The weekly magazine made an announcement that from the next week onwards, this magazine will publish the autobiography of the convicted prisoner as a serial. What was juicy for the magazine about the autobiography of a convicted criminal was that the autobiography contained references to several officers, including police officers, whom, according to the convicted person, were partners in the commission of his crime. Therefore, the police wanted to prevent the magazine from publishing all these stories, and that led to the 1994 judgment of the Supreme Court in R. Rajagopal versus State of Tamil Nadu. Two conflicting rights had to be considered by the Supreme Court in this case. Freedom of the press, the right to privacy, they were on one side, and the freedom of the press and the people's right to know were pitted on one side, with the right to privacy of the government officials who claimed that the publication of this autobiography will harm their reputation. The Supreme Court said as follows, I quote, the right to privacy, this is the first case where the origin of the right to privacy was identified, not lying in constitutional law, but lying in the law of tort. That was the beauty of this judgment. The Supreme Court said the right to privacy as an independent and distinctive concept originated in the field of tort law under which a new cause of action for damages resulting from unlawful invasion of privacy was recognized. This right had two aspects which are but two faces of the same coin. Number one, the general law of privacy, which affords a tort action for damages resulting from an unlawful invasion of privacy. And number two, the constitutional recognition given to the right to privacy, which protects personal privacy against unlawful governmental intrusion. The first aspect of this right must be said to have been violated where, for example, a person's name or likeness is used without his consent for advertising or non-advertising purposes, or for that matter, his life story is written, whether laudatory or otherwise. In recent times, this right has acquired a constitutional status. We shall proceed to explain how right to privacy is not enumerated as a fundamental right in our Constitution, but has been inferred from Article 21. This is what the Supreme Court concluded in Rajagopal. That is why this case assumed significance. Then following this R. Rajagopal came the next judgment in People's Union of Civil Liberties versus Union of India. What was in challenge in that case was Section 5, subsection 2 of the Indian Telegraph Act, which permitted interception and tapping of telephonic conversations. Without striking down the statutory provision, the court laid down certain parameters for the exercise of such a power under Section 5.2. While doing so, the Supreme Court reaffirmed that the right to privacy is part of the right to life and personal liberty enshrined in Articles 21 of the Constitution. The next decision was a very important, very interesting case. It was not about state intrusion into somebody's privacy, but it was an individual's intrusion into another person's privacy. That was a case reported as Mr. Yaks versus Hospital Z. In this case, the hospital revealed a secret, a confidential information that Mr. Yaks underwent a treatment for AIDS. Therefore, his marriage was called off. This man sued the hospital, and the Supreme Court held that the right to privacy may, apart from contract, also arise out of a particular specific relationship, which may be commercial, matrimonial, or even political. As discussed, doctor-patient relationship, though basically commercial, is professionally a matter of confidence, and therefore doctors are morally and ethically bound to maintain confidentiality. In such a situation, the public disclosure of even true private facts may amount to an invasion of the right to privacy, which may sometimes lead to the clash of one person's right to be let alone with another person's right to be informed. Disclosure of even true private facts has the tendency to disturb a person's tranquility. It may generate many complexes in him and may even lead to psychological problems. He may thereafter have a disturbed life all through. In the face of these potentialities, the right to privacy is an essential component of Article 21 of the Constitution. That's what the Supreme Court held. Of course, some of the observations contained in Mr. Yaks versus Hospital Z were later expunged in a subsequent judgment, and they were held to be not expunged, they were held to be not reflecting the correct law on the point, but they had nothing to do with the right to privacy. The next milestone in the journey of the right to privacy was the decision again in People's Union of Civil Liberties. This arose out of a challenge to Section 33B of the Representation of the People's Act. What happened was, in the decision rendered by the Supreme Court in Association of Democratic Reforms, the Supreme Court upheld the Election Commission of India's regulations for the disclosure of criminal antecedents of the candidates contesting elections. They set the assets and liabilities of persons contesting the elections and their family members. The educational qualifications of the persons contesting elections will all have to be revealed to the candidates. That was the judgment in Association of Democratic Reforms. In order to annul the effect of the judgment, Section 33B was inserted into the Representation of Peoples Act. Therefore, that Section 33B came under challenge in People's Union of Civil Liberties. While declaring the amendment, the Supreme Court declared the amendment to be unconstitutional, and while doing so, the Supreme Court said, by a declaration of fact, which is a matter of public record, that a candidate was involved in various criminal cases, there is no infringement of any right of privacy. Interestingly, another facet of the right to privacy with respect to registers and documents in the possession of public authorities came under consideration in yet another case, which was reported as District Registrar versus Canara Bank. In this case, a particular provision, amendment to the state amendment to Section 73 of the Indian Stamp Act. The state amendment is imposed by the state of Andhra Pradesh. Andhra Pradesh inserted an amendment to Section 73 of the Indian State Stamp Act, which required the banks to furnish the data available with them about the transactions, monetary transactions entered into by a particular person. The only objective of the state amendment was to ensure that the money actually transacted between two parties whenever a document was registered tallied with the sale consideration reflected in the document presented for registration. That was the only objective. Interestingly, individuals did not challenge the validity of Section 73 of the Stamp Act, but Canara Bank challenged it. When that case reached the Supreme Court said the right to privacy and the power of the state to search and seize have been the subject of debate in almost every democratic country where fundamental freedoms are guaranteed. Therefore, the court held that intrusion into privacy may be by three methods. Number one, legislative provisions. Number two, administrative or executive orders. And number three, by judicial warrants. If right to privacy is sought to be invaded by legislative provisions, those provisions must pass the test of reasonableness. If the right to privacy is sought to be intruded by administrative orders, their ultra-virus has got to be checked up. If they are sought to be intruded by judicial warrants, they must be subjected to well-known parameters for judicial decision-making. This is how the court defined the contours. After this judgment, all of you know that Aadhaar came. A little background about this Aadhaar may be necessary for the younger members of the bar. In March 2006, an approval was granted by the Department of Information and Technology of the Government of India for a project titled as Unique Identification Project for Below Poverty Line Families. In 2009, an institution by name UIDAI was constituted as an attached office of the Planning Commission. By September 2010, the enrollment process began. In November 2012, after 2 years of the commencement of the enrollment process, in 2012, the Aadhaar scheme came under challenge. When the challenge came up before a 3-member bench of the Supreme Court, the Government of India took a stand that the right to privacy is not a constitutionally guaranteed right according to the judgment rendered way back in 1954 in MP Sharma versus Satish Chandra. That judgment was delivered by a 8-member bench of the Supreme Court. Therefore, the Government of India contended that Aadhaar scheme cannot be challenged before a three-member bench on the ground of violation of the right to privacy when the issue has already been sealed by a eight-member bench way back in 1954. When the Government of India took this particular stand, the three-member bench before which the Aadhaar scheme came under challenge was confronted with a very peculiar situation. On the one hand, they had the 1954 judgment. On the other hand, they had a series of judgments starting from Karak Singh up to Mr. X and PUCL. Therefore, the three-member bench referred the matter to a five-member bench. Then the five-member bench of the Supreme Court referred this matter to a nine-member bench only for answering one question whether right to privacy is a constitutionally guaranteed right or not. In August 2017, the nine-member bench in what has now come to be very popularly known as Justice Puttaswamy's case answered the reference pointing out that right to privacy is part and parcel of the right to life and liberty under Article 21, and that it actually emanates not merely from Article 21 but also from the tripart of Articles 14, 19 and 21. So the nine-member bench, by judgment in August 2017, answered the reference that the right to privacy is part and parcel of the Article 21 under the tripart. After answering this reference, the nine-member bench sent the cases back to the five-member bench for a decision on the merits of the Aadhaar scheme. But by that time, Aadhaar Act 2016 had already come into force. The law until then was that right to privacy had to be tested on a case-to-case basis. Therefore, in the light of the statutory scheme which had come into force in 2016, what would be the fate of this right to privacy was the question that was to be decided after the remand to the five-member bench by the nine-member bench. Eventually, the five-member bench upheld Aadhaar Act. The constitutional validity was upheld, but certain safeguards were directed to be maintained. Strong data protection laws were directed to be made. Pursuant to the direction issued by the five-member bench in August 2018, a personal data protection bill has now been introduced, and I believe it has now been sent to the Joint Parliamentary Committee comprising of about 30 members, because many people, including Justice V.N. Sri Krishna, who was involved in the preparation of the draft data protection bill, has raised concerns about the final draft that has been placed before the Parliament. So the journey in India of the right to privacy started with MP Sharma in 1954, and we have come up to 2019 with this personal data protection bill. Keeping this in mind, now I will move on to the second part of my lecture, tracing the historical development of this law relating to right to privacy in the Western world. In the year 1604, Sir Edward Cook declared in a case called Peter Semine versus Richard Grisham that a man's home is his castle and fortress, as well for his defense against injury and violence as for his repose. This was in the context of the sheriff of the town attempting to effect attachment of movable properties kept in a house. The owner of those goods had incurred financial liability to someone who got a decree and got an order of attachment. But by the time the order of attachment was sought to be executed, the immovable property had been purchased by someone else, and the sheriff sought to get into the immovable property for effecting the order of attachment. Therefore, the owner of the immovable property, namely the house, sued that his right was violated, and it was in that context that Sir Edward Coke said, "A man's house is his castle and a fortress." This doctrine of a man's house is his castle, articulated in 1604 by Sir Edward Coke, was presented in a much better, in a more lucid form by William Pitt, the elder, who was the Prime Minister of Great Britain. This William Pitt said something very interesting. I quote, "The poorest man in his cottage may bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England shall not enter." That is how William Pitt articulated this right to privacy. This principle, articulated in England, was later transported to United States, where it was given a very interesting development by Henry Grady, a journalist and editor. Henry Grady, in 1800, he said as follows, I quote, "Exalt the citizen. As the state is the unit of the government, he is the unit of the state. Teach him that his home is his castle and his sovereignty rests beneath his hat." I unquote. After nearly 300 years of the exposition of this doctrine by Sir Edward Coke, an article appeared in the Harvard Law Review in 1890. That Harvard Law Review article dated 15th December 1890. Today we are on 14th December 2019. Tomorrow it will be about, 129 years. 130th anniversary tomorrow. This article in Harvard Law Review was titled "Right to Privacy" and was written by two alumni of the Harvard Law School itself. In fact, one of them went on to become the judge of the US Supreme Court. The names of the authors were Samuel Warren and Louis Brandeis. Brandeis became the judge of the Supreme Court of the United States later. This article, authored by both of them, is considered to be one of the most influential essays in the history of American law, and it is the first publication in the United States on the right to privacy. In simple terms, the authors described the right to privacy as a right in terms. But the American courts had an occasion to consider the scope of this right for the first time in a case titled Olmstead versus United States. It was in 1928. Olmstead was prosecuted for violating National Prohibition Act. The conversations that Olmstead had with his employees and business associates were tapped by the government through wiretaps attached to the telephone wires found in public streets. He had a telephone connection at home. Tapping was done not directly in his phone, but on the telephone wires in public streets. Olmstead challenged this evidence on the ground that they were unlawfully collected by violating his right to privacy. Supreme Court said, US Supreme Court said, after all these wiretaps were attached to the cables in the public streets, there was no direct search and seize operation. Police did not enter your house. Therefore, so long as the police did not enter your house, your right to privacy was not affected. That was the view taken in 1928. But exactly 40 years later, in 1969, this decision in Olmstead was overruled by the United States Supreme Court in Cards versus United States. Look at the interesting development within a period of about 40 years. In 1928, the wiretaps were attached to the cables in the public streets. The conversations made inside the house were tape recorded and used in evidence. Supreme Court upheld it. In 1969, this person cards, he went out to make phone calls from a public booth. By attaching an eavesdropping device, his telephone conversations made from a public booth were tape recorded and used as evidence. Supreme Court said it violated the right to privacy. When the court was questioned as to how could there be a right to privacy when a person had gone to a public telephone booth outside his residence, the Supreme Court, Justice Stewart articulated this right in a very lucid manner. I will quote Justice Stewart. He said as follows, I quote, "One who occupies a telephone booth shuts the door behind him and pays the toll that permits him to place a call. Therefore, he is surely entitled to assume that the words he utters into the mouthpiece will not be broadcast to the whole world. Therefore, the right to privacy arose." That was the logic that was developed by Justice Stewart in that judgment. A completely different dimension of the right to privacy was developed by the United States Circuit Court of Appeals for the Second Circuit in Helen Laboratories versus Top Chewing Gum in 1953. The question was whether a man had a right to publicity of his own name. Is it part of the right to privacy? Was the question involved. Top class baseball players sold their own reputation to the plaintiff company so that the plaintiff company can put the pictures of those baseball players in the chewing gum that they manufactured. They had an exclusive contract. But what these players did was, they also entered into an agreement with another competitor company. Therefore, a fight between two companies arose. The question was whether a man had an exclusive right as to who should use his photograph and who shall not use his photograph. Why this case assumed significance was that previously the usage of a person's photograph even without his consent was not considered to be violative of any right. As a matter of fact, a company manufacturing cigar was using the photograph of a very famous lawyer and politician. When that company was sued, that case, which was reported as Atkinson versus John Doherty, the court said, if somebody uses your photograph, you have no right in your photograph. If the purpose of usage of your photograph was to scandalize you, then you have a right. That's how they developed. Subsequently, in another case, Hanna Manufacturing Company, the Fifth Circuit held fame, a person's fame, is not merchandise. It would help neither sportsmanship nor business to uphold the sale of a famous name to the highest bidder as property. This is what 1935 said. From 1935 to 1953, there was a complete transformation, and the Second Circuit Court said it's all right if a person's photograph can be sold for a price, he is certainly entitled to do it. Today, from that state, look at the kind of endorsements of products, goods and services that celebrities make today. In fact, most of the celebrities make huge money in endorsing products than they make in playing sports or playing titles in films. The next case to come up in the US was a 1965 decision in Griswold versus Connecticut. The question involved in this case was about the right to marital privacy. the use of contraceptives was banned under a law in a particular state. On the ground that the directors of a medical firm were advising married couple on the use of contraceptives, they were prosecuted. The Supreme Court declared the law to be unconstitutional, and the Supreme Court asked this question: would we allow the police to search the sacred precincts of marital bedrooms of telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. End quote. Next came Stanley versus Georgia, where the residence of a person was searched for finding out whether he was indulging in bookmaking, which was an offense. In the course of search, police did not find any material what they were looking for, but they found pornographic material inside his house. When those material was seized and he was prosecuted, the US Supreme Court set aside the conviction, holding the right that the appellant is asserting in this case before us, the right to read and observe what he pleases, the right to satisfy his intellectual and emotional needs in the privacy of his own home, the right to be free from state inquiry into the contents of his liberty. Thereafter came the famous controversial judgment in Roe versus Wade. In Roe versus Wade, a lady sought advice about abortion. There was a Texas law prohibiting abortion except where it was necessitated upon medical advice. The US Supreme Court held that the due process clause of the 14th Amendment to the Constitution provided a right to privacy that protects a pregnant woman's right to choose whether or not to have abortion. In fact, this decision in Roe versus Wade vertically divided the American society into two groups, one advocating pro-life and one advocating pro-choice. This decision was partly overruled after 19 years in a decision called Planned Parenthood versus Casey. However, the constitutional right of a woman to have abortion was upheld even in the subsequent decision. Thereafter, in 1953, following the European Convention, Great Britain enacted the UK Human Rights Act in 1998, recognizing for the first time that the European Convention rights are binding and they are enforceable in England. Sexual preference of a person became the subject matter of controversy in Lawrence versus Texas, where under the 14th Amendment, the criminalization of homosexuality was set aside in 2003. The retention by the police of DNA and other biometric data, even after a person was cleared of criminal charges, was held in R versus Commissioner of Police of the Metropolis to be violative of Article 8 of the European Convention. The installation of a GPS device on the car of a person suspected of violating narcotic laws was held by the Supreme Court in 2012 to be violative of the Fourth Amendment in the United States versus Joseph. This case also concerned the tapping of the movements of a person through a GPS device. Justice Sotomayor developed a very interesting concept in this case. She said, the moment information, up to this decision, what was thought of was that suppose I speak in a public platform, I share information with few friends in a WhatsApp group. I am putting the information into the public domain. The moment I put my information into the public domain, I have forfeited my right to claim privacy over what I have said in a forum. That is what was thought until this decision came in 2012. But Sotomayor said, your right does not merely stop in keeping your thoughts confidential, but your right extends to the persons with whom you want to share it and beyond which you do not want to go. If I do not wish to share a particular information beyond a group of 6 persons, 12 persons, that is an enforceable right to privacy, was what Justice Sotomayor said. Then 2014, the Riley versus California came up as a very important judgment in the context of use of our mobile phone data. The digital contents of a mobile phone data were held to be not admissible in evidence by the Supreme Court in 2014, US Supreme Court, if such contents were obtained through a warrantless search. If a warrant had been taken and the digital contents had been downloaded, it was perfectly all right, but it was not open to the police without a warrant, by a warrantless search to download the contents and use them. Justice Roberts made a very interesting observation in this Riley versus California. He said, I quote, "Modern cell phones are not just another technological convenience. With all they contain and all they may reveal, they hold for many Americans the privacies of life." Justice Roberts explained that modern phones expose to the government far more than the exhaustive search of a house not merely contains in digital form many sensitive records previously found in the home, but it also contains a broad array of private information never found in any home in physical form. We store a lot of things at home in the physical form. A normal police, a conventional police search and seizure will take hold of only what is found physically. But in digital form, whatever ugly thoughts that we have are all stored, and it will be very dangerous for a police to look into the ugly side which you may not expose even to your spouse. This was in essence the decision in Riley versus California. That now completes the second part of our discussion about the historical development starting from Sir Edward Coke in 1604 to this Riley versus California in 2014. Now let us come to what we are into in this digital age. There was a company by name Sun Microsystems. That is an American company which created Java programming language and an operating system called Solaris operating system. That company has now been sold. It's no more there. The chief executive officer of this Sun Microsystems, by name Scott McNeely, he declared in the year 2000. Remember, we are in 2019. In the year 2000, this Scott McNeely declared, "Privacy is dead, deal with it." This is what he said. Privacy is dead, deal with it, he said in 2000. Taking clue from what he said, Brock Meeks, an award-winning investigative journalist and MSNBC.com's chief Washington correspondent, wrote an article. The title given by him to the article was, "Is Privacy Possible in Digital Age?" This article was published in MSNBC on 8th December 2000. The topic that we have chosen for discussion is the right to privacy, new age challenges. Therefore, the third part of our discussion is about the new world, new age challenges, digital age challenges. This Brock Meeks said in his article the following, I quote, "Privacy in the digital age may not be as dead and buried as McNeely believes, but it is certainly on life support. Our unbridled love affair with all things technological, has an evil twin, a seemingly unstoppable encroachment on our personal privacy. The same streaming video technology that allows grandma and grandpa to chat with their grandchildren is being used to spy on employees in the workplace or capture unsuspecting lovers stealing a kiss. This is what Brock Meeks said about the right to privacy in the digital age. This was said in 2000. Before we could wake up in 2017 with Justice Puttaswamy and reinstated, science and technology and law all over the world has swept everything under the carpet. The magnitude of the issue raised by Brock Meeks and Scott McNeely was realized by the world of netizens only in the year 2013. On June 6, 2013, the British newspaper The Guardian published a story. The title of the story was NSA PRISM program taps into user data of Apple, Google and others. NSA is National Security Agency of the United States. It talked about a program called the PRISM program. After 3 days, the newspaper Guardian revealed that the source of their information was a person by name Edward Snowden. Edward Snowden was a 29-year-old employee of a company by name Booz Allen Hamilton. Booz Allen Hamilton had a contract with NSA and they hired Edward Snowden to work at the Threat Operations Center at Hawaii of the National Security Agency. While working there, Edward Snowden downloaded more than 1 million highly classified documents. After downloading more than 1 million documents, Edward Snowden flew to Hong Kong on 20th May 2013, from where he contacted select journalists from Washington Post and Guardian, and he started revealing all these secrets. Guardian and Washington Post started publicizing these articles. Washington Post published a story in October 2013 under the caption, NSA infiltrates links to Yahoo, Google data centers worldwide. This shook the entire world of netizens. PRISM was NSA's electronic surveillance program, and it is an acronym for Planned Tool for Resource Integration, Synchronization and Management. That is what was described by the acronym PRISM. Snowden's revelation showed that the two most powerful governments of the world were accessing phone records and user data of millions of people around the globe, including leaders of other countries. What was interesting was that even the technology giants such as Microsoft, Google, Facebook, none of them knew about it. They never had a clue about the snooping, because how the snooping was taking place was by tapping the optic fiber cables that were going undersea. At the interjunction of two countries, if optic fiber cables lying underneath the sea are tapped and the data are collected, no two governments will have any control over jurisdictional issues. Therefore, you youngsters should actually remember that while you are busy watching Big Boss, a big brother is actually watching you. Therefore, whatever you watch is being watched by somebody except probably your parents. When we talk of snooping by governments, we must also keep in mind that the moment we enter into the world of net, we create huge footprints. We leave a trail which enable a lot of other people to know exactly where you are at a particular point of time, what you are doing, what your likes and dislikes are, and what your habits are. Today I can tell you, Google knows that I was born in Vishaka Nakshatram Vrishchika Rasi, because whenever there is a transit, planetary transit takes place, like Rahu is transiting, Jupiter is transiting, Venus is transiting, my mailbox is bombarded with mails about how this transit will impact persons belonging to Vrishchika Rasi. Therefore, you must remember that Google knows everything about you, including your star of birth and including your Rasi in which you were born. How do they know this? Have we ever asked this question as to how they come to know about this? In fact, third parties who know all about you because of the way you use the internet fall under 4 categories. Number 1, the governments and law enforcement agencies. All the law that has developed both in the West and the East talk about intrusion by government and government agencies. But government and law enforcement agencies constitute only one of the 4 third parties who know all about you. The second category of persons who come to know all about you are the service providers. The third category of persons who come to know about this are information providers. And the fourth category are the hackers. Snowden merely exposed the first category of people, but not the other 3 categories. Who are the second category of people? Second category of people are those who exploit you by virtually selling you as a product to those who want to sell products to you. What do? Suppose I want to take a flight to Chennai today and I just type in Google search Kochi to Chennai. Thereafter, every time I open the Google, I am advised by several online portals which operate in the travel sector as to which are the cheapest flights, which are the earliest flights. You may suppress the information about your travel to your wife, but Google knows. But Google maintains strict confidentiality and they don't tell your wife. That is the only difference. The third category of people who know all about you are those who provide free access to certain information. Suppose you want to know about something, about a particular law. There are a lot of online journals which provide you this information. The moment you type this, that online journal comes up. When you start reading, at the bottom, a message pops up. That message says, "We use cookies. Do you mind?" Some of us think that cookies are good along with coffee or tea because they are only eatables. But the cookies that they are talking about are completely different. The moment you say yes, then they know your complete habits and they start bombarding your mail. These are the third type of people. There is a fourth category of people who know everything about you. They are the hackers. I should tell you a very interesting case, and with that, I think I'll wind up. The superintendent of police of the cybercrime branch of the Hyderabad police, once met me and told me a very serious but interesting case that came before him. A college girl met the superintendent of police of the cybercrime branch of Hyderabad and told him about a very peculiar blackmail threat that she was receiving. She was receiving a threat from some unknown person that unless she paid money, a huge amount of money, he will start publishing the nude photographs of this girl. This girl had never taken any nude photograph. There was no way anybody could have taken a nude photograph. Therefore, the Superintendent of Police advised her that it could be a hoax. But the girl said, "Sir, it cannot be a hoax because I also did not believe. I have never taken any photograph. Therefore, I first ignored. But in order to prove that he is in possession of such a photograph, he sent me a sample copy, and that was actually my photograph. It was actually a semi-nude photograph." This Superintendent of Police became curious and suspicious. He started inquiring about her habits, her friendships, etc. When he found nothing against her, the only possible clue was where she was directed to transfer the funds. She had already sent a part of the money through an online transaction. Therefore, when the person to whom the money was ultimately in the account into which the money was deposited was traced, it was found that that was a fake account. The bank had allowed a person to open an account without following that KYC norm. KYC norm is know your customer norm. The money had already been withdrawn. They could not find a trace. Therefore, the only way the police could trace was to find the IP address of the person who was sending this threat. I hope some of you at least may know that all of you have an IP address. The IP address is in digital form. Since IP address is in numbers, since numbers cannot be remembered, we all convert it into words. Behind these words, every one of us is identified by a number. But the IP address is always masked by the search engine because they don't want every person to break into your privacy. They don't want the identity of the sender to be known. It is not easy to find out the real IP address of a person unless you have a police warrant against Google. The Superintendent of Police had to take a police warrant, and then when he got the IP address, he traced the Blackmailer to Khattab in Orissa. When he landed up in the residence of the Blackmailer in Khattab, who had nothing to do with Hyderabad, he was shocked to know that Kotak person, Blackmailer, had never known this lady, had nothing to do with this lady. Then how was he operating? He was operating in a very interesting manner. I hope all of you download some good songs, some good pictures, some interesting facts in our mobile smartphones or in our laptops or desktops. Whenever you download something, you think that somebody is offering you something free of cost. There are hackers who upload interesting material on the net for you to download. While they upload interesting material, they upload it along with a particular virus. Therefore, when you download what was uploaded by him, you download it along with the virus into your laptop. What does this virus do? Very interesting. All your laptops have a camera. Generally, if we want to take a picture, we switch on the camera. But there is a particular virus which does not require your permission to activate the camera. What had actually happened in the case of this lady was sending mails, etc. One day she had to rush to her office. Therefore, without shutting down the computer, she went, took a bath, came out, changed her sari, and this virus which had activated the camera had captured her image and sent these photographs to the blackmailer, who started sending blackmailing messages. Normally in the physical world, actual physical world, only people who know you threaten you. In the virtual world, it is actually, I don't know how many of you have seen a movie which came about 50, 60 years ago. The title of the movie was Maya Jal. How many of you have seen that movie? Maya Jal. It's a Tamil and Telugu movie. Only one person must have seen it, just but virtual world is a world of Maya Jal. One need not know the identity of another either to help you or blackmail you or extract something from you. Therefore, this case revealed that there are hackers who can go to the extent of activating your camera on the laptop to capture your images. This is what digital age has done to your privacy. Before I wind up, I think I'll take 5 more minutes about 2 interesting cases. Apart from the fact that digital age has challenged the way we look at our rights, our own perceptions about personalities, our preferences, our choices have also changed the dimension of the rights to privacy in a different way. This was demonstrated by a case which came up before the UK High Court. It concerned the right to self-identity, which is now read and recognized as part and parcel of the right to privacy. How I identify myself as a man or as a female, a man born as a man but identifying oneself as female, a female born as a female but identifying oneself as a male. This issue came up for consideration in a very interesting case. A and B, a normal couple, married and they got a first child. After the birth of the first child, the father developed a desire to become a female. A course of feminizing hormone treatment was undertaken by him, which required 2 years of living as a female before a referral was made for gender reassignment surgery. In the meantime, while he was in the process, this 2-year process, his wife conceived for a second time. She delivered. By the time she delivered, the father actually got converted into a female. There was no problem about this. But what he did was, he went to the Registrar of Births and made a very peculiar request. He said, look, my wife has delivered a baby. You normally enter the father and mother's name. They have now changed the format into parent 1 and parent 2. Therefore, about the second child, there was no issue. But he made a request to the Registrar of Births to change the name of the father in the birth certificate issued to the first child on the ground that I am no more Mr. Yaks. I am now Miss So-and-so, therefore please change the entry in the birth register of my first child, which was born when I was Mr. X and my wife was Mrs. X. The registrar did not know what to do. He simply rejected, as our own government officials will also do. Because what do our government officials now do? Sir, I will reject it. You go to court and get orders. Because they are all under the impression that the courts are there to pass any orders that people want. Ultimately, what the court did in this case was, court said, all right, Article 8 of the European Convention recognizes your right to family preferences, your right to personal choices, which is part of the right to privacy. But there is a countervailing interest in protecting the identity of the child. The child was born to Mr. X and Mrs. X about 2 years ago, about 3 years ago. If today the entries in the birth register are altered, your identity is recognized by law, but your child's identity is destroyed. Therefore, we have a countervailing interest to protect the child's identity. Hence, we will not allow you to exercise this right. Such types of cases, with our modern outlook, with the development of our personal choices, have also started coming up. Therefore, in today's digital age, technology throws up huge challenges to our rights to privacy. The way we perceive our rights, the way we perceive ourselves, the way we look at things, the way we look at values in our system, whether personal values or societal values, have also completely changed, leading to new dimensions of right to privacy being created and old dimensions of right to privacy being destroyed. And that is how this new age challenges have come up. With these few words, I thank you very much for the opportunity.